New York State Racing, Parimutuel Wagering, and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor, by and with the advice and consent of the Senate. 4 members confirmed by the New York State Senate are necessary to afford the commission an ability to establish a quorum and undertake action. This present meeting of the commission is now called to order. This meeting is being conducted in conformity with Chapter 1 of the laws of 2022. Such chapter authorizes state and local government entities to meet and take such action authorized by law without permitting public in-person access to meetings, and authorizes such meetings to be held remotely by conference call or other similar service, provided that the public can view or listen to such proceeding, and that such meetings are recorded and later transcribed. Accordingly, this commission meeting is being conducted in conformance with such allowance, and we are allowing both the public to listen to our proceeding, and we are recording today's meeting for transcription as required. Ms. Secretary, will you please call the roll?
John Crotty.
Here.
Peter Machete.
Here.
John Baclemba.
Here.
Christopher Riano.
Here.
Barry Sample.
Here.
Jerry Skurnick.
Here.
Ms. Secretary, will you please have the record reflect that a quorum of qualified members are present, thus enabling the transaction of business? Chairman Sample?
I recommend that Peter Machete be the chair for this session. I am operating remotely, and if no one has any objections, I think for continuity, it's best that Peter chairs this session since he is with Rob and agency staff.
I'm in. All right. First matter, consideration of the minutes for the meeting of November 8th, 2021. The minutes have been provided to members in advance. At this time, I'd like to ask the members if there are any edits, corrections, or amendments. Hearing none, Ms. Secretary, please let the record reflect that the minutes were accepted. Now, second matter is rulemaking. New York State Racing, Parimutuel Wagering, and Breeding Law, Section 104.19 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibility. As a result, the Commission will, from time to time, promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. Today, we have 1 rule for adoption and 6 proposals for consideration.
For Commission consideration is adoption of regulations to establish discretion to require a thoroughbred jockey to serve a suspension for a riding violation at the same track which the violation occurred. A notice of proposed rulemaking was published in the September 15th, 2021 State Register, meaning that the public comment period expired on November 15th, 2021. 1 public comment was received, this from the Jockeys Guild. The Guild opposes codifying this penalty as a policy as a regulation. Instead, they suggest that hearing requests brought in bad faith should subject a jockey to sanctions if the appeal is found to be brought frivolously. The Jockeys Guild also suggests that the regulation be amended to allow jockeys who are suspended for minor riding violations for 10 days or less to be permitted to ride in designated races during the suspension, serving a day of the suspension at a later time to make up for the designated race day. The Guild suggests that such a policy may decrease the number of jockey challenges. In the alternative, the Jockeys Guild states that if the proposed rule is adopted, it should retain the provision allowing for steward discretion whether a penalty should be served at the same racetrack. Staff notes that Commission Rule 4550.11 contains a provision to assess an additional penalty for a frivolous appeal, which is defined as 1, commenced in bad faith or for purposes of delay, or as one that is unreasonable and without substance or merit. That current rule puts the burden on the Commission to prove frivolousness at an additional hearing. The staff believes that this has created an insufficient deterrent for jockey appeals taken for the purpose of delaying serving the suspension. Due process is observed in any requested riding infraction hearing. This rule would not change the Commission's burden to establish a rule violation. Once a violation is found, the proposed rule would create the discretion to direct when the penalty is served, furthering the integrity of each race meet. Staff believes that allowing the jockeys to race in more lucrative designated race days during a suspension would diminish the deterrent to careless riding and other track infractions. Staff recommends that the Commission adopt this rulemaking.
Do the Commissioners have any questions on the adoption of a rule permitting discretion to require a thoroughbred jockey to serve a suspension for a riding violation at a track where the violation occurred? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Is there any discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? The motion carries.
For Commission consideration are amendments to the regulation governing licensing requirements for a jockey's agent. This proposal would remove the requirement that a person applying for a license as a jockey's agent have been licensed and have acted as an exercise person, apprentice jockey, assistant trainer, or trainer in this or in another jurisdiction for at least 1 year. The proposed changes would instead allow the stewards or another commission designee to determine whether an applicant is qualified by reason of experience, background, and knowledge. The proposed amendments to the rule would be consistent with the requirements for an applicant for a jockey's agent's license contained in the model rules of racing issued by the Association of Racing Commissioners International. The model rules of racing do not require contain a requirement to have been licensed in another capacity for at least a year. Staff recommends that the Commission authorize this proposed rulemaking.
Are there any questions on the proposal of an amendment to the jockey agent qualification rule?
No.
Hearing none, may I have a motion to propose this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? The motion carries.
For Commission consideration are amendments to the current Thoroughbred Pick 5 rule. This proposed rulemaking would amend Commission Rule 4011.25 to allow each Thoroughbred racetrack the option of carrying over 100% of the net pool or carrying over 75% of the net pool and paying out a consolation of 25%. Prior written approval of the Commission would be required before a racetrack could change the method of apportioning a Pick 5 pool. This proposal is similar to rules in effect in other jurisdictions such as California, Florida, Kentucky, and New Jersey, which mirror the model rules of racing issued by the Association of Racing Commissioners International. Staff believes that the proposed changes to the Pick 5 rule would give tracks more flexibility and discretion to remain competitive on a regional basis and recommends that the Commission authorize the proposal of this rulemaking.
Do any of you have questions on the proposal of an amendment to the Thoroughbred Pick 5 rule? Hearing none,
No.
may I have a motion to propose this rule?
So moved.
Second?
Second.
Is there any discussion on the motion? Hearing none, all in favor?
Aye.
Opposed? The motion carries.
For Commission consideration are amendments to the current Thoroughbred and Standardbred Pick 4 rules regarding consolation pools and carryovers. This proposed rulemaking would amend Commission Rules 4011.24 and 4122.46 to allow a Thoroughbred and Standardbred racetrack the option of offering a consolation payout for Pick 4 wagers. The proposed rulemaking would allow tracks to either carry over 100% of the net pool or carry over 75% of the net pool and pay out a consolation of 25%. Prior written approval of the Commission would be required before a track could change the method of apportioning the Pick 4 pool. These changes would mirror the proposed changes to the Thoroughbred Pick 5 rule, which were just considered, and mirror the current Thoroughbred Pick 6 rule. This proposal is similar to rules already in effect in other jurisdictions such as Florida, Kentucky, and New Jersey. Thus, staff believes that the proposed changes to the Pick 4 rule would give racetracks more flexibility and discretion to remain competitive on a regional basis. Staff recommends that the Commission authorize this proposed rulemaking.
Are there any questions on the proposal of amendment to the Thoroughbred and Standardbred Pick 4 rules? Hearing none, may I have a motion to propose this rule?
So moved. So moved.
Second?
Second.
Any discussion on this motion? Hearing none, all in favor?
Aye.
Aye. Aye. Aye.
Any opposed? The motion carries.
For Commission consideration are amendments to the jockey equipment weighing rules in thoroughbred racing. This proposal would rename Commission Rule 4033.3 to Items Weighed with Jockey from Weighing Out, and would eliminate jockeys being weighed with muzzles, martingales, and breastplates. This proposal originates with our state stewards who have noted that racetracks in California, Florida, Kentucky, New Jersey, Pennsylvania, and Texas do not have jockeys weighing out with these items. Staff recommends that the Commission authorize the proposal of this rulemaking.
Does anyone have questions on this proposal? Hearing none, may I have a motion to propose this rule?
So moved. So moved.
Second?
Second.
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye. Aye. Aye.
Any opposed? The motion carries.
For Commission consideration is a proposed rulemaking to establish a standard time period for requesting a hearing on horse racing license determinations, set forth acceptable service methods for the Commission, and set forth the duty of licensees to keep addresses updated for the Commission. New York Racing Parimutuel Wagering and Breeding Law, Section 321, provides that an applicant for a harness racing license must request a hearing to challenge a denial within 10 days after notice of the licensing decision, but there are no similar requirements for other types of racing licenses other than quarter horse racing, which is not currently operating. This proposal would administratively set consistent time periods for when a license hearing may be requested for all racing licensees. That is 10 days from receipt or 15 days from mailing if the notice has been sent by first-class mail. Once requested, a hearing date would be set for a later date and the agency adjudication process would take place. Acceptable methods of service for all Commission matters would also be prescribed.
Does anyone have any questions on the proposal to standardize racing license hearing request and service methods? Hearing none, may I have a motion to propose this rule?
So moved.
Second?
Second. Second.
Does anyone wish discussion on the motion? All in favor?
Aye. Aye.
Any opposed? The motion carries.
The final rule for consideration today is an amendment to the regulations governing mandatory coupling of entries in thoroughbred racing. Commission rules generally require coupling of entries in certain circumstances that bettors may perceive to present a conflict of interest among competitors in the event. Included in these types of requirements is when a jockey has a familial or other types of relationships with each other or with trainers in the race. The history of the rule is unclear, but it appears that the rule might have been intended to address concerns with spouses testifying against one another and an attempt to mitigate bettors' concerns that a party may not expend maximum effort when competing against a related party. Last year, the Senate and the Assembly passed legislation that would have prohibited the Commission from requiring a coupling of entries in thoroughbred horse races when a horse is trained or ridden by a spouse, parent, issue, or member of the household of another jockey in the race. Governor Kathy Hochul vetoed the bill, but directed the commission to review the continued need for the mandatory coupling and circumstances under which a requirement may be relaxed, and to seek input from industry stakeholders and the wagering public regarding this topic. Following the governor's direction, commission staff conducted a public hearing on January 11th, 2022. The hearing received input from the assembly sponsor, a racing law scholar, and industry stakeholders on both the jockey coupling issue and with the general topic of potential conflicts in sports events upon which wagering occurs. One comment that resonated with staff was made by William Gadamer, who noted that the New York rules sought to protect the public from a particularized harm, yet the state allowed New York patrons to wager on simulcasts of races that allowed the exact behavior prohibited in state. Accordingly, after consideration of views expressed at the hearing and noting that the racing industry is trended towards national uniformity of rules, staff recommends removing the requirement to couple entries with jockeys with a relationship among them or other participants in the race. The commission steward would retain the discretion to require coupling in any circumstances in which the steward concludes coupling is necessary in the public interest, which should continue to protect the interests of the wagering public in unusual or unforeseen circumstances in a particular race. In addition to making this recommendation, staff notes that review and consideration of how to address misuse of confidential, non-public inside information in all contexts of wagering activity continues, and we will report on that at a future date.
Are there any questions on the proposal to remove jockey coupling standards in thoroughbred racing? Hearing none, may I have a motion to propose this rule?
So moved.
So moved.
Second? Does anyone wish discussion on the motion? All in favor?
Aye.
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 Any opposed? The motion carries. So in the context of the various rules we just proposed, I feel compelled to note that the Federal Horse Racing Industry and Safety Act was created in part to establish a nationwide standard for medication and safety matters due to the interstate nature of horse racing activities and their participants. I think the rules and the conduct of racing are similar. For instance, the Pick 4, Pick 5, and Pick 6 rules are mostly consistent between states, but there are permutations state to state with treatment of scratches, of course, surface changes, and carryovers. This can cause confusion among the many race patrons who wager on interstate simulcasting. I appreciate the work of HISA to date, but recommend that they seek the authority to standardize the conduct of racing activity. So next, we have adjudication. Today, we have 4 matters for adjudication, and Mr. Williams will start off with the first.
In the matter of Eternal Deli, Inc., on March 1st, 2021, the Bureau of Licensing issued a notice of license suspension for alleged crimes to Eternal Deli, Inc., which is located at 115 Main Street in Hempstead. The notice informed Eternal Deli of a temporary suspension for engaging in conduct that constituted fraud, deceit, misrepresentation, or conduct prejudicial to the public confidence in the state lottery. Specifically, the proprietor of Untitled Deli was reportedly arrested on February 23rd, 2021, and charged with misdemeanors of possessing an illegal gambling device and promoting illegal gambling. Eternal Deli requested a hearing, which was conducted on October 26th, 2021. The hearing officer submitted a report dated October 28th, 2021, recommending that Eternal Deli's license be revoked. The commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial meetings exception of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered these matters and determined upon a vote of 6-0 to sustain the hearing officer's report and recommendation. The next matter, please.
In the matter of Richard Banca, in March 2020, harness racing owner and trainer Richard Banca applied to renew his state racing license. On December 10th, 2020, the commission issued a refusal to renew his license on the grounds that his experience, character, and general fitness are such that participation in racing or related activities would be inconsistent with the public interest, convenience, or necessity, or with the best interests of racing generally. The licensee requested a hearing and redetermination on his license renewal application, which was conducted on September 15th, 2021. The hearing officer submitted a report dated November 25th, 2021, recommending that Mr. Banca's license renewal be refused. The commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a 6-0 vote to sustain the hearing officer's report and recommendation. Next matter.
In the manner of Amira Chakali. On September 17th, 2021, the state steward at Belmont Park fined thoroughbred trainer Amira Chakali $2,000 for transferring a recently claimed horse to another trainer within 30 days of the claim in violation of Commission Rule 4038.4. Ms. Chakali requested a hearing which was conducted on November 10th, 2021. The hearing officer submitted a report to the Commission Secretary dated January 11th, 2022, recommending the imposition of a $2,000 fine. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a 6-0 vote to sustain the hearing officer's report and recommendations.
In the matter of Timothy Masters, on October 6, 2021, the presiding judge at Yonkers Raceway fined racetrack employee Timothy Masters $1,000 for using profane language, citing Commission Rules 4119.2 and 4119.9A. Mr. Masters requested a hearing which was conducted on December 8, 2021. For the hearing, the commission staff amended the charges to alleged violations of 4119.1 related to conduct and 4119.9 related to prohibited acts. The hearing officer submitted a report to the commission's secretary dated January 6, 2022, recommending that a fine of a violation of Rule 4119.1, but not of Commission Rule 4119.9, and recommending the imposition of a $250 fine.
The commission duly deliberated and considered this matter and determined upon a vote of 5 commissioners to sustain the hearing officer's report and recommendation. Commissioner Crotty abstained from voting. Next matter, please.
That's all the adjudication, sir.
All right, so we'll be on to new and old business. Is there any new or old business to be considered? Hearing none, that would conclude today's published agenda. So we traditionally have met on the fourth Monday of each month, which for March would be the 28th. For planning purposes, Secretary Buckley will be in contact to consider availability. So if there are no other items for consideration, this meeting of the New York State Gaming Commission is adjourned.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Well done.